All right, Pat, Chris Baldwin here. I'm going to go ahead and mute the music, and I'll ask you to go ahead and unmute. And you, sir, have the floor.
Great. Thanks, Chris. Good morning and welcome. We're pleased to have so many of you join us this morning for Neola's annual, or what has become an annual policy forum for our Michigan school district clients. I'm Patrick Corbett, and together with Amanda Clapp and our Neola staff, we welcome you this morning. Glad that you could join us. We're pleased to feature our primary legal counsel with Varnum, Charyn Hain, and our partner with the Michigan Association of School Boards, Brad Banasik, who is their Director of Legal Services and Labor Relations. They will be providing you with some of the content guidance. Let me start off, first of all, by congratulating you on all of your efforts for your school operations and weathering the storm thus far. And we appreciate your efforts on behalf of students in Michigan and their families, and certainly your district staff. This policy forum for a number of years has been an annual event conducted together with the MASA Fall Conference. We've sponsored that for a number of years, and unfortunately with the coronavirus changes that we have all had to experience, a number of rearrangements to schedules and events has occurred. MASA conducted their fall conference in August this year and did it virtually. We were unable to come up with a way to host a virtual golf outing, but did want to maintain the policy forum as an assist to you, and thought that keeping things at this time of year would provide a comfortable buffer for you to get things rolling and perhaps generate a few questions that we could address over the course of this morning's conversation. Just a couple of comments by way of introduction. We are most honored to be your policy service provider. Several reasons we think you have chosen Neola. And the first of those would be the fact that we're a comprehensive service. We provide you with policy guidance with regard to governance, school district operations, educational program and activities, students, human resources, and school finance. We make sure that our policy templates and the information that we provide for you is current. We typically provide you with 2 updates each year, and specials as needed in between those two updates. And I'll recap some of those efforts in just a moment. We also warrant our templates to be compliant with both Michigan and federal law, and rely upon Varnum, as well as Brad and his folks at MASB, along with several of our federal legal counsel, to make sure that we are on top of programs nationally. Finally, our policy templates are connected to a set of administrative guidelines to assist you in your implementation of those policies. They are connected also to best practice identified among school districts. We maintain connections with the Michigan Department of Education, Michigan Department of Health and Human Services, and other government agencies. We also stay well connected with our partners at MASB, also with MASA, and our Michigan associates who work directly with you on a very regular basis represent many years of public school district service in Michigan in the guidance and the assistance they provide to you. Quick look back to what this year has meant. Typically, you will get an update from Neola in early to mid-February, and then another one in early to mid-September. Just looking back over the last 6 months, we have had cause to provide 5 different special updates to you, one in March, another one in April with a couple of legal alerts and a sample resolution. Followed that with a special update, legal alert on Title IX regulations, We issued, because of compliance timelines, a new policy and administrative guideline on Title IX regulations in July. And then recognizing your need for some additional guidance and information, we were able to issue Volume 31, Number 1 update about 6 weeks sooner than we normally would have, and got it out to you in early August. So your associate is available to guide you through many of those items. And if you haven't been in touch, I'm sure they will be in contact with you very soon. We have several content issues to share with you this morning. We'll kind of take turns between Charyn, starting on back to school issues, and then follow with Brad on various roles and responsibilities around that Michigan Safe Start Plan. We'll also spend some time with the Title IX regulations, and then wrap things up in content presentation, discussing a couple things on political expression and dress code issues. We also have received a number of questions from you that if we don't cover them in our content sessions, then we will follow that up with a question and answer period as we wrap things up. So thanks for joining us this morning. Sit back, relax, and I'm going to turn things over now to Charyn Hain.
All right, Charyn, give me 1 second. We're going to get you unmuted and spotlighted.
Okay.
And did you need to share your screen, Charyn?
No, not for this one.
Okay. You have the floor.
Good morning, everyone. I assume you're out there. This is very strange to be doing it this way, but I'm glad we were able to do something to provide you some time to talk to us directly at the end, and then also to address some of the pressing issues. So the first topic's fairly broad. I would like to just remind you of a few things, because I'm assuming much of this has already been done by your district, and then address what I think might be some questions that may come up repeatedly throughout and across districts. So as I'm sure you know, each district has to have an extended COVID-19 learning plan submitted to its ISD by October 1st. And that plan has the new changes, the changes to the State Aid Act, outline exactly what you need to have in that plan. And it's a pretty lengthy list of issues. That list of issues is also contained and outlined in a legal alert that you should have received in late August. So I'm not going to take our time today walking through that, but if anyone has specific questions that aren't addressed here, we can talk about them later. So the extended COVID-19 learning plan is very important because it's going to trigger some protections and some changes that the law allows districts to avoid some of the laws that have been in effect for a very long time if you have your COVID-19 learning plan to the ISD by the 1st of October. One of the questions we've been hearing is, does the Board of Education have to approve the COVID-19 learning plan before you submit it to the ISD? And the answer to that is no. The law does not require that to happen. Obviously, getting people's input into whether they agree with your COVID-19 learning plan, getting as much community support and input is good, but the board does not have to formally approve it before you submit it to the intermediate school district. That being said, the board does need to thereafter monthly reconfirm the plan in an open meeting where the public, and including especially parents, are allowed to provide input as to how this plan is working. Again, that has to be done monthly. I believe the law actually says every 30 days, but I would put it on your monthly board agenda. It's going to have to be reconfirmed. And I'm assuming you're going to probably end up with a decent amount of public comment, particularly if issues are arising with how it's being implemented due to factors such as having to shut down for a COVID-19 exposure. Also, a few other things to note on that learning plan and related to that is that progress reports are due to the state by February 1, 2021. And then a second progress report is due no later than before the end of the school year. So if your school year end's going to end June 15, 2021, make sure you get that report in before that date. A few other changes. As I mentioned before, certain things are waived if you have your COVID-19 learning plan in place. And one of those things is the hours and days requirement. So if you have your plan in place with the ISD by October 1, then for this year, only the 1,098 hours, 180 days requirements will be waived. So you do not have to demonstrate, therefore, that you have complied with that specific aspect of the law for this school year. However, because the legislature probably doesn't really pay that much attention on a day-to-day basis as to how schools are administered and children receive instruction, but that's just my personal opinion, you do need to deliver the same content that you otherwise would have provided within that 1,098 hours, 180 days. It's a little unclear to me, at least, how they're going to check that. It could very well be through the progress reports, but do keep in mind that the legislature at least expects the same education to be provided to students, however you are providing it, blended, solely online, all in person, that you would have given if the hours and days requirements were in place for the school year. As you probably already know as well, the count days and the methodology have changed too, and obviously that's significant for funding issues. I am not going to walk you through the mathematical formula. That actually is outlined in that legal alert you received. But the primary change is that instead of looking at who's in seat on your count days this school year, what they're going to do is they're going to take 75% of your count for 2019-2020, and use that number. And then the other 25% is going to be based on a mathematical formula related to this year. And they've come up with formulas also to determine how to count online students. Again, I'm not going to go into detail on that because we could spend the whole hour talking about it. That too is in the legal alert that was sent out, so hopefully you have it. But the primary thing to keep in mind is that to be allowed to count online students, one of the primary requirements is that you have to be able to demonstrate at least 2 interactions per week with 75% or more of your online student base. Interactions is also defined in the statute. What a two-way interaction is. It's pretty broad, in my opinion. It can be anything from email to a phone call to an actual face-to-face conversation, which I'm assuming they mean virtually face-to-face. But you have to be able to demonstrate that in order to count that particular student if they're doing online. A few others, so that's a really broad, high-level summary of the State Aid Act changes. And obviously there are more changes than just those, but those are the primary ones that we have been dealing with. Brad's going to talk later about board resolutions, so I'm not going to touch on that. I will let Brad discuss that in the next topic area. As you also know, you are not just dealing with the State Aid Act changes, you are also trying to figure out what executive orders apply and how to comply with them. So right now, you're still under Executive Order 142, which talks about having your preparedness plan in place and obviously breaks it down by what phase your district is in. If you're in phase 4 or higher, you have the ability to do in-person, and you need to have a plan in place as to how you're doing that with all the hygiene requirements and the other requirements, face mask requirements. All of this is outlined in the executive order as to face masks and that type of thing. But it's also the state put out, and you probably have seen a roadmap. It's a 63-page document with essentially a series of checklists. And that will tell you what is required depending on what phase your district is in. And it will also tell you what's strongly recommended and what's recommended. Strongly recommended obviously is not the same as required. But That being said, you certainly can implement things that are strongly recommended. So for example, if you are in an area where certain obligations don't apply because you're in phase 5, then you still can choose to impose them on your district employees and students. And so these are going to be things that I think are going to need to be made on a district by district level basis, depending on what your community attitudes are, depending on what your actual active COVID-19 case is. Is it ramping up? Is it steady? Is it going down? And obviously in conjunction with the advice and recommendation and continual communication with your local health department. Another thing that has come up that is probably of interest under the executive orders is workers, your employees. So the EO 142 was clear that EO 114 still applies to school employees. So that needs to be taken into factor, talks about working remotely, how to protect workers, that type of thing. Another executive order that comes into play is 176, which relates to meetings in part and relates to more than that. And it also covers athletics. So 176 applies, by the way, be really clear here just so no one gets confused. If you are in region 6 or 8, this does not apply to you. The other regions, it does. So you still are prohibited from having meetings for work indoors if of more than 10 people, and outdoors events are prohibited of more than 100 people. Again, regions 6 and 8 are excluded from this. But what that means in practical terms is if you're doing professional development indoors, you're going to have to make sure that the grouping in person is limited to 10. This doesn't mean that, I'm trying to think of the word they use, but it's like essentially random or non-planned groupings is different. But if you're setting up a specific meeting for your teachers, your administrative staff, anyone, you're going to have to limit it if it's indoor and in person. If you're still enjoying good weather and want to hold it outdoors, you've got it limited to 100 people. Sports obviously is complicated on many levels. And as I said to a client, both the joy and the horror of being allowed to have fall sports, right? So in some sense, it's great. Everyone wants to get out there. Everyone wants to return to normalcy, but we have to do it in a very abnormal environment. So for sports, I'm just going to touch on this, but under Executive Order 176, if your sporting event is indoors, your athletes are allowed to designate 2 guests. There are mask requirements for everyone. I'll get to the mask part in a little bit more detail in a moment. If it's outdoors, if you have football, it's limited to 2 guests also, but a max of 100 people. So if I'm understanding it correctly, you can then have a grouping of more than 10 people indoors for a volleyball game, for example, even though you're not supposed to have meetings of more than 10 people, but outdoors you're still limited to the 100 people. So now masks, as you probably all know, the mask order is being held to apply to student athletes. MHSAA put something out on this. You probably all saw that. Their position is, we can't end run around the governor's executive orders. This is what the executive orders say. Generally speaking, face coverings have to be worn. And by the way, let me stop there. Face coverings. If I use the word mask, ignore that for athletics. It's face coverings. And so that is not defined. That could be a face shield. It could be a gaiter. It can be anything. It just has to cover the nose and the mouth area. So face coverings are required to be worn by student athletes in most sports. Exceptions are swimming while they're swimming and diving, and then also cross country, golf, and tennis while the student's actively participating. So Football, soccer, volleyball, face coverings are required. And this includes times during active participation as well as while the students are on the sidelines. Obviously, MHSAA will, if this changes, and I think there's some possibility maybe this will change now that Big Ten football is coming back. I think they're kind of going to push this. So maybe U of M, MSU, et cetera, will give us some latitude for high school sports. But for right now, that is the executive order on face coverings, and they are required except for the limited exceptions under the executive order. I'm going to stop here because we only have 40 minutes left and we have 3 very important topics that we probably could also, again, spend a whole hour talking about. Questions at the end, let us know. Thank you.
Thank you, Charyn. Although many times it seems as though you're in this alone, you're not. You have other people who are very much vested in the success of school operations. To talk about some of those roles and responsibilities as you implement your Safe Start plan, happy to call on Brad Banasik.
Thank you, Pat. First of all, good morning, everyone. Happy to be presenting with the Neola group today. And this is going to be the shorter part of my presentation. The subject of political expression and First Amendment and dress codes will be a little bit longer. So just have a couple slides on this topic of roles and responsibilities. So let me pull up my screen here. All right, policy issues, pandemic and politics. So we're going to first talk about the pandemic side of it. Who's making the decisions, the roles and responsibilities during a pandemic. And, right off the bat, you had Executive Order 2020-142. This is the executive order that kind of outlines, how school districts must operate during the 2020-21 school year. And it does make a specific reference to the board approving a district's preparedness plan. And, when I read through these laws, read through the executive orders, read through the bills, you really have to read them literally as far as defining who has the roles and responsibilities in carrying out these requirements. And when a law or order says district, so a district must approve, that doesn't necessarily mean the board. And that kind of what Charyn referred to in the extended learning plan. There was quite a bit of confusion originally over that language about whether a board was required to approve the extended learning plan, because it said the district would have to approve that plan, but that doesn't mean the board has to approve it. So the way I interpret legislation, if it says the board must approve, then that has to be approved by the board. But if it says it must be approved by the district, then that's going to be controlled by your policies as far as the policies addressing that issue of what must be approved and whether it's the administration approving that or the board approving that. So another example of the law specifically indicating when the board must approve something is the hiring of teachers. In the revised school code clearly states that the board shall employ and hire and contract with teachers. Thus, that's not something that can be delegated to your administration. The ultimate approval of those teachers must come before the board, and the board must approve teachers by a majority vote. But you see in Executive Order 142, the initial preparedness plan had to be approved by the board, but the extended learning plan does not, as Charyn previously indicated. Another question I've been getting frequently is, okay, who makes the decision to close a school building when we have a COVID-19 outbreak? Is the board required to be involved in that decision? Is the board required to make that decision? The law, the executive order, and the return to school plan are both silent on this issue. You can see here, I have a quote from Executive Order 142. is that if you have a positive test among staff and students, this is required. It's not recommended in the order or the return to school plan. It's required that all schools must cooperate with your local health department and collect contact information so you can have that tracing data that can be shared with the local county health department. So the school will likely be making the decision on whether it should close a building or not. But it's going to come in cooperation with your local county health department. The board doesn't necessarily have to be involved with that decision. It could be. The administration likely would touch base with the board president on that issue, but it's not required by law. Likely the administration does have the unilateral authority to make that decision of closing a school building when there is a COVID-19 outbreak. It doesn't necessarily require a decision by the board, but it could. And if the board is involved in that decision, I would say that likely merits an emergency meeting under the Open Meetings Act. Under the Open Meetings Act, you can have an emergency meeting without 18 hours notice if you are addressing an issue that could risk the health and safety of your students and staff, and the only way to alleviate that risk is to have an immediate meeting. I think under those circumstances, if it's been decided that the board is going to be involved in closing a school building due to an outbreak or going back to complete remote learning due to an outbreak, you could have an emergency meeting under those circumstances, and the board can make that decision. But once again, under law, the board isn't required to make that decision. So another question I've been getting frequently is the resolution to grant emergency powers to the superintendent during the 2020 and 21 school year. Neola is recommending such a resolution. I know law firms are also recommending such resolutions. Early on during the pandemic, MASB had a sample resolution on its website as well. So I think this is the best practice. So I get the question, what does MASB think about these resolutions? I think they're needed under the circumstances. This is the time when the board has to trust its administration. And adopting this resolution shows that there is trust in the administration, that it's going to be making decisions in the best interest of the health and safety of students and staff. So what does this resolution do if it's passed by the board? It will weigh policies or policy provisions that are necessary to comply with executive orders or respond to any COVID-19 related issues, and also implementing your preparedness plan as well as your extended learning plan. Taking lawful actions to comply with executive orders, ensuring the continuation of your public education, providing for the health and safety of your student staff, and to respond to any orders and directives from the governmental authorities. In most cases, the board will be involved with approving a contract based upon the amount of public expense involved in that contract, based upon a financial threshold in policy. But what the resolution does, it does allow the administration to enter into contracts of any dollar amount for the purchase of materials, equipment, supplies, or services in order to address COVID-19 issues. But it has to be consistent with all applicable state laws and federal laws, okay? So we do have a state law that requires bidding and board approval on purchasing equipment and supplies of a certain threshold. And I believe that number is about $24,000 right now. So that can't be waived. Any expense that's going to be over that amount still has to come before the board for approval. The resolution does not suspend that legal requirement. But in terms of services are not required to be bid out under the revised school code and are not required to be approved by the board. So if you have a service expenditure that exceeds that $24,000 amount, that can still be, that contract can still be entered into without board approval. Okay, is services does not require bidding, does not require approval by the board. And then you'll see in the last statement here, the administration can institute new policies and procedures implementing executive order preparedness plans. So essentially adopting policies on face covering, mandatory quarantine measures, and limiting access to school buildings, which is important. So for example, let's say you have a building use policy that allows community groups to use your building facilities currently. That policy could be suspended at this point, or the administration could create a COVID-19 building use policy. Now, my recommendation would be, even though your athletic teams are using your facilities, I would not let outside groups use your facilities at this point. The liability is just too great. There are so many requirements that have to be followed. To me, when you look at the risk benefit in that situation, the risk clearly outweighs the benefit of allowing your community groups to use your district facilities. So in my opinion, I would suspend a policy, create a new policy or rule that clearly states we are not going to be allowing outside groups to use our school district facilities, during the pandemic at this time. And that concludes the first part of my presentation. So I'm going to pass it back over to Pat.
Thanks, Brad. Just one caution: if you do let one group use your facilities, then you're leaving it open to all groups. You cannot pick and choose. Therefore, Brad's advice to just say no to all outside organizations may be the safest course of action. During the past several months, since early in March, you've had to face a significant number of challenges. Under normal circumstances, it would be real easy to understand that some of the details, changing requirements, could receive delayed attention or perhaps unintentionally slip through the cracks. One of the reasons we've provided you with regular updates and ongoing policy guidance is to avoid that from happening. And with one of those very important items, Title IX regulations, there are some new regulations that have been provided. On May 6th, Secretary DeVos issued new regulations with regard to sexual harassment under Title IX. Although litigation is still pending and a number of lawsuits have been filed, Federal District Court in Washington failed to issue an injunction or any kind of a stay or delay of implementation. Therefore, the announced August 14th effective date for these regulations is in play. And the new definitions and the procedures put forth in this regulation are there for you to follow. And we have issued Policy and Administrative Guideline 2266 for your use. At this time, I would ask Charyn Hain to provide a brief overview. It's rather detailed, and 10 to 15 minutes certainly won't do it justice, but perhaps a brief overview right now, Charyn, would be in order.
Thanks, Pat. I'm going to try to share my screen here. Hopefully pull up the right thing. Okay. And I'm going to start from the beginning. Maybe.
Top left corner under file.
Yep.
There you go.
Okay. All right, there we go. Okay. So this is an overview of the Title IX policy, the new policy Pat just mentioned. I'm really not going into detail on the administrative guideline at all, but it tracks obviously the policy. As Pat said, I've given presentations on this that have lasted over an hour, so this is going to be really high level, and my apologies, but this at least hopefully will give you a heads up on some issues. So briefly, why are we here? Because as Pat said, in May, They put out 2,003 pages of new regulations on Title IX. The primary changes, or a couple of the primary changes, was to limit the scope and to provide a definition of what's covered by limiting the term sexual harassment. I do want to spend a minute here because this is all in the policy, by the way. So this should, if you have 2266 and you look at it, this is all there. So the scope changed because now the off-campus events that weren't school sanctioned, didn't occur at school, those are not covered under Title IX. And anything that happens out of the United States. So when the world returns to normal and you take a field trip to Toronto or down to Mexico for some, the biology class, anything that happens there is not covered under Title IX. They also defined Title IX and limited it to quote unquote sexual harassment, which is a defined term that I'm not going to walk you through, but it's laid out in the policy. So these changes could be fairly significant. I know a lot of my district clients dealt with Title IX almost primarily based on off-campus, non-school related Saturday night parties, where two students had issues. Now, that doesn't mean you can't do anything or shouldn't do anything about those types of situations. So please keep that in mind. What it says, though, is that it's not covered by Title IX, so you do not have to follow all the hearing processes and rights in the Title IX policy. Again, if you have something going on, related bullying, anything like that, you need to address it, but it's not going to be Title IX, and Title IX will not be triggered. The other thing to point out here, too, is that actual knowledge for K-12 school districts is all board employees. So anyone who has actual knowledge of an event that could be triggered Title IX is going to be held responsible to report this to the Title IX coordinator, all board employees. But the policy, we had an option to include students as reporters and board members. I think that's great. But the board employees are absolutely required under the law under the new regulations to report. So again, we got three primary categories of individuals that the districts are going to have to appoint. First, you need a Title IX coordinator. The Title IX coordinator can be whoever you want. If you are a bigger district that has a robust enough human resources department, it certainly can be someone there. It could be the superintendent. It's going to be dependent on where you are and what your situation is, but you must have someone listed as your Title IX coordinator. We recommend, if you are able, to have a female and a male Title IX coordinator. There's also going to be investigators. I put an S because I would recommend you have more than one in case there's an allegation of bias or conflict. The investigators, I'll talk more about what their role is. A Title IX coordinator can also be an investigator. So, you could, and I would recommend, should train your Title IX coordinator to investigate complaints as well. Then there's what's called a decision maker. So they have separated the role of investigating and making decisions on whether a person's responsible. So there also has to be someone or more than one person who is a decision maker under Title IX. The Title IX coordinator cannot be a decision maker. And for the specific complaint, the decision maker cannot be the investigator. Now, it doesn't mean that you can't have three people who are trained as investigators and one investigates the specific situation and then a different one's the decision maker in the specific situation. That's fine. You can have overlapping roles. You just can't have the person who investigated the specific complaint also make a determination of responsibility in that specific allegation. So who reports? Anyone can report. And it needs to be reported to the Title IX coordinator. You have options in the policy as to how that reporting should occur. I think we're going to put out a form for the report. Please understand that while you can have a form, you cannot require someone to use it. So if someone files a complaint and never fills out the form, you are not allowed to fall back on we didn't get our official form filled out, so we didn't investigate. If you have enough information in writing, you need to go forward. So Supportive measures. This is essentially, the immediate remedial effects. Does the person who made the complaint need counseling? Does the person who made the complainant, need some type of assistance with rescheduling their classes or other types of things? That must be assessed by the Title IX coordinator, even if no formal complaint is ever filed. And I'll try to give you a little more background on formal complaints in a moment. So again, I could report that someone told me they were sexually harassed. The Title IX coordinator then needs to contact the complainant, if the complainant's not the party making the complaint, and ask them if they need anything, and then go forward. And we'll get more into the going forward in a second. Emergency removal. I bring this up because there are new procedures in place. So if you are going to remove a student from an education program or activity, including athletics, the person who's in charge of this, and you could designate the Title IX coordinator or have a broader group, has to do an individualized safety and risk assessment. And no, they don't tell us what that looks like. So that's going to be gathering as much information as you can and sitting down with the respondent, trying to figure out what's going on. And you can only remove them on an emergency basis if they're an immediate threat to the physical health or safety of another. That's also a change. So, because it's limited to physical. No longer is it appropriate for someone to say, I can't have so-and-so in school. They need to be kicked out or temporarily suspended because I feel uncomfortable or I'm emotionally threatened. No, it has to be physical health or safety. Now, well, I'm going to leave that at that. There could be different definitions of what physical health means that could encapture some of the more emotional, but that's a definite change and needs to be paid attention to. So we have somebody file a complaint to the Title IX coordinator. Let's assume it's the complainant. If it's the complainant, him or herself, then that person needs to determine if they want to go forward. And file a formal complaint, which is really not anything specific. It's just saying, I want to go forward with an investigation. But the only people who can file a formal complaint, not bring it to the Title IX coordinator's attention, but file a formal complaint requiring them to go forward, is going to be the complainant or the Title IX coordinator, him or herself. In my opinion, the Title IX coordinator probably is not going to decide to file anything unless this is a situation where this is a repeated course of conduct and this individual has not been held accountable for, or it was so severe that it's really something the district has to deal with, even if the complainant doesn't want to go forward. And then the regs do address, what happens when you have a reluctant complainant. We just don't have time today to go into all this, so my apologies. But the regulations address it, and the policy does as well. So investigation protocols, it's all laid out in policy. There's notice requirements. There's hearing rights. Hearing is, we call it a hearing even if it's not live. We'll talk about live hearing in a moment. But there's also the use of advisors. The regs state that anyone can be an advisor, so we cannot anymore take a position that the person cannot have an attorney advise them. We can't limit that anymore. So the investigator is supposed to investigate this by talking to anyone and everyone that's relevant and issue an unbiased report with input from the parties prior to finalizing. Again, I could spend 2 hours walking you through all this, so I'm really sorry I'm doing it so quickly. The key thing, though, in the investigator decision maker distinction is they want the investigator to be unbiased. This report should contain absolutely no suggestion of whether this happened or not, should not give the person's opinion on who they believe. It just is factual, just the facts, ma'am, right? So that's all it should be in this investigator report. Then that goes to the decision maker following the process set out in the policy. This is the person who actually determines whether the respondent is responsible. I'm not going to spend time talking about the standards, but there's options to choose a clear and convincing standard or preponderance of evidence standard. That will affect what level of proof the person, the decision maker, is looking at. There are also fairly detailed live hearing protocols only if you chose live hearings. Please don't choose live hearings. You didn't hear that from me, but I would never recommend any of my district clients to choose a live hearing. K-12 does not have to have live hearings. Higher ed does. But even if there's no live hearing, you need to allow the parties to submit written questions and answers and get answers to those questions. And then you need to provide them the opportunity to follow up prior to the decision maker making his or her decision. So the decision maker will then issue a report as well. And in that, there's stuff that the person has to lay out that's in policy. So you have to substantiate your findings. Again, that's in our policy. We don't have time to go through it in detail. But as to sanctions, the decision maker will make a recommendation and provide it to the Title IX coordinator, who will send it to the appropriate administrator, maybe building level, maybe the superintendent. If there's a recommendation for a sanction, and for example, it is expulsion of a student, then you have to then implement your other due process under your other policies. And I know this sounds ridiculous, but I'm sorry, that's just the way it is. And they didn't really think this through. So I say that a lot. But that is what needs to happen. If there's a finding of no responsibility,
And I'm not sure if she's coming back. So we're going to go ahead and probably come back to Pat, unless Charyn comes back here momentarily.
Something happened with our connection there.
I believe so.
So let's stop at this point on Title IX, and we'll shift gears and ask Brad to comment on. Certainly, 'tis the season, and the political environment is charged and demanding a great deal of time and energy and attention. And with that, your thoughts turn to how do you control all of that in a school environment? And while you do have policies and administrative guidelines to work with that, Brad, we're going to ask you to offer some thoughts and some suggestions for how to move as smoothly as possible through this minefield.
hey, sorry everyone, I'm back. And if you want the PowerPoint, Pat can push it out because there's only 1 or 2 slides left.
Okay, well, thank you, Pat. So we left off on the First Amendment here, and this implicates obviously political expression and your dress codes. So student employees do not check their First Amendment rights at the schoolhouse gate. I'm sure as an administrator, as a board member, you've heard that statement countless times. It comes from the case of Tinker versus Des Moines, Iowa. But it's important to know that your school is not the state capitol building. Okay, the First Amendment rights that apply at the state capitol building don't apply at your school building. So you, as a school, you have a duty and a recognized authority to limit expression in order to maintain the safety and the learning environment that you have to have in a school district. So you certainly take that into account in establishing your dress codes and regulating any type of student or staff expression. So what is protected speech? Not all speech is protected by the First Amendment. Speech that is political, religious, or expresses an opinion through spoken or written words, that's considered to be pure speech and obviously is protected under the First Amendment. Expressive conduct or symbolic speech is only going to be protective if an individual intends to convey a particularized message, and then that message has to be understood by those who observe it. And that kind of brings us into dress codes. Do strict dress codes infringe on students' free speech rights? And dress codes will certainly come into play with student expression in regard to political speech, but it comes into play as well with wearing symbols or images that could be perceived as being an incentive to particular classes or all individuals. So the issue of, can we have a restrictive dress code that states no slogans or written images or pictures on T-shirts? Is that something that is allowable under the First Amendment? Well, let's find out. We actually have a court case on this, a decision from the Sixth Circuit, and the Sixth Circuit does cover Michigan, so this decision is binding in Michigan and binding in Michigan, Kentucky, Ohio, and Tennessee as well. So the district adopted a very strict middle school dress code. You can see what it restricted there on the middle bullet point. And as luck would have it for the school district, you had a middle schooler whose dad was an attorney. And the dad felt his daughter's First Amendment rights were being violated, in addition to his recognized parental rights to direct the education of his child. So he sued the school district because of this very restrictive dress code. The Sixth Circuit ruled in favor of the school district. It went back to what is protected speech and recognized that in order to sustain an expressive conduct claim under the First Amendment, someone has to show that the conduct conveys a particularized message, and the likelihood is great that it will be understood by those who view it. And the court indicated that in this case, the plaintiffs have not met their burden of showing the First Amendment protects the student's conduct. In this instance, the student just wanted to express how she was feeling about the way that she was going to dress that way, and that's not an expressive conduct that's going to be understood by those who view it. So think about how we're all dressed today. What am I trying to express? Yes, I'm trying to express some sort of professionalism with my dress, but beyond that, really not trying to express any type of message just by wearing a collared dress shirt today. So that's what was recognized by the court. And also the court emphasized this was a viewpoint neutral policy, a viewpoint neutral dress code. It wasn't discriminating against any particular viewpoint. And if it did, that's when a district, could run into trouble, when it focuses on a certain type of message and is restricting that message. So as viewpoint and content neutral, it served an important governmental interest. The district had data showing that strict dress codes in many cases lead to better learning. You don't have the bullying of other students based upon how a student is wearing expensive clothing or not. And also the policy did allow students of other avenues to express themselves at school. In the parental right issue, just a quick comment on this. I know this comes up often in with parents saying, I have a right to direct my child's education, so you're interfering with that right with this dress code, or making my child read this book, or making my child do this assignment. Yes, parents do have a fundamental right to direct their child's education, but it essentially stops, right at the interest of the school. I have a parental right to send my child to a different school if I wish, but once my child is in that school, my parental rights are somewhat limited. So I can't direct the school curriculum. I can't direct the hours of the school day, school discipline. And in this case, the parent could not direct, what type of dress code the district was going to apply to its students. So that did not interfere with the parents' fundamental right to direct their child's education. That's been recognized by our U.S. Supreme Court. So applying the ruling, districts are on a stable ground with a dress code that focuses on student clothing in general, rather than a particular message, a particular viewpoint. So if you adopted a dress code that said no political messages on T-shirts or any clothing, that would be problematic, because you're focusing on a particular type of viewpoint. But if it's no messages, no images on student clothing, that's content neutral, viewpoint neutral. So you wouldn't run any trouble with that type of dress code. So just some points here about regulating student dress, whether it's in school or remote learning. While someone is participating online in a class, the student code of conduct still applies. So someone cannot wear an offensive or lewd saying on their t-shirt while participating virtually in a class. So just remember that, this would apply both to in-person learning and to remote learning as well, as long as you can tie it to a legitimate educational reason. So for example, if you traditionally had a dress code that says no sweatpants, I would advise not to apply that to learning at home. Many of us working at home like to wear sweatpants. So requiring students to not wear sweatpants while doing remote learning, to me, that likely wouldn't accomplish any type of legitimate educational objective. So avoid vague or overbroad policies. Make sure they're clearly worded to place students on notice of a particular type of dress that is prohibited. And most importantly, enforce equally among all the student population. You don't want to have any gender bias claims based upon how you're enforcing your dress code. So what is protected speech? We talked about this a little already. Political speech, written speech, symbolic speech that conveys a message that's going to be understood by those who see it. How can you restrict that speech? Well, you can restrict it if it's materially and substantially interfering with the district learning environment or interferes with the rights of others, if it's vulgar, lewd, or obscene, or promotes activities that are illegal, such as illegal drug use. And all of these standards have been substantiated by our U.S. Supreme Court. Obviously, the first standard you see there, that's from the Tinker versus Des Moines, Iowa case that I referred to earlier. So it can get tricky, as far as what is considered to be lewd or political speech. This case here almost made it to the U.S. Supreme Court. Was so close to the court addressing this issue. But as you can see from the bracelet there, that those bracelets are worn to show support for individuals experiencing breast cancer or survivors of breast cancer. But as middle schoolers will do, middle schoolers in this particular school district were wearing these bracelets because they thought they were funny, really didn't understand the political meaning of these bracelets, and the district decided to prohibit them. This case went to the Third Circuit. Third Circuit isn't binding in Michigan, but did provide some interesting analysis on this case. Generally said school districts must differentiate between ambiguously lewd speech and plainly lewd speech. So the court said the term boobies is ambiguously lewd. It's really not plainly lewd. So the ability to for a district to regulate ambiguously lewd speech is diminished because it's not plainly lewd. And then you should also consider and weigh whether the possibly lewd speech is addressing a political initiative. And if it is, it's going to receive more protection. So that's what the analysis was based on in this Third Circuit case. And as a result, the Third Circuit determined that the school district violated the students' free speech rights in restricting the students from wearing these bracelets. Almost went to the Supreme Court, but the Supreme Court denied it on appeal. So Confederate flag images, this continues to be a hot issue for school administrators as far as regulating Confederate flag images on clothing or on vehicles parked in the school district parking lot. We have a lot of precedent in our U.S. Sixth Circuit Court of Appeals that has upheld bans on displaying the Confederate flag. Importantly, you're not required to wait for this type of student expression to cause an actual disruption before taking action, but you must be able to reasonably forecast that the image will cause a material and substantial disruption based upon specific facts. So it's really important, to document instances where you've had, tensions within your school district that you think could be heightened because of the image of the Confederate flag. And use those facts than to prohibit the display or the image of the Confederate flag. And then the last case that looked at this issue also added an additional analysis element to it, that schools have a substantial interest in educating students in an environment that's conducive to fostering knowledge and democratic learning. That kind of goes back to the Fraser case of inculcating students with democratic ideals and having a curriculum that furthers that. So that's another element that can be taken into consideration on this matter. So political activities on school property. So we're in an election season. Boy, the next month or so, it's going to be crazy. The commercials are already out in full force, and certainly people are taking sides. And hopefully we'll all get through the next couple months and get to the other side of this. So just want to make you aware of some of the policies that you have in your Neola manual that should be applied during election season. And these policies have been adopted to ensure that districts are avoiding Campaign Finance Act violations. The Campaign Finance Act prohibits a school district from using district resources, whether it be physical resources or financial resources, to support a candidate or ballot proposal. And that's what Policy 9700 does. It ensures that no district resources, no district finances are being used for the purpose of advancing a special political interest. The second policy statement does that as well, ensuring that school facilities and equipment are not being used for producing any materials that promotes a political party or a political candidate. And the students and employees shall not be used to distribute campaign literature within the schools on school grounds. Now, we'll get into the issue a little bit of not using students to display political literature, but may a student on his or her own behalf display campaign or hand out campaign literature on school property. And then lastly, you'll see the last policy provision there about promoting any type of political candidate during with school district advertising. Obviously, a prohibition due to the Campaign Finance Act. You also have this law, the Political Activities by Public School Employees Act. It does allow your school employees to engage in political activities on behalf of a candidate or issue related to partisan or nonpartisan elections. However, clarifies this cannot happen during the school day while a school employee is being compensated for performing their public duties. That's in violation of the law. So that's where the line is drawn. Obviously, staff members can be involved in politics on their own time, but cannot bring that onto school property during the school day while they're performing their duties and responsibilities as a school staff member. You may, as an administrator, may adopt rules for staff that ban attire containing political messages during the school day, and make sure that it's without regard to the content of the message. So while you cannot ban students from engaging in political expression, unless you have a very, very broad dress code that does that's viewpoint neutral, you can do that with your staff members. This is the viewpoint neutral regulations that have been held not to violate the First Amendment. Teachers may now this is a tricky issue as well, discussing political issues and candidates in class, but if it's done as part of an instructional activity in a viewpoint neutral manner, that is permissible. And lastly, what about students handing out political literature? Talked a little bit about this previously. You have a case here from the Sixth Circuit that addresses this issue. The policy required prior approval to distributing non-school sponsored literature and only allowed it to be distributed in the cafeteria. So the district set reasonable time, place, and manner restrictions, and said students, you can't do it in the hallway, only at lunchtime at a table in the cafeteria, or you can post flyers in the hallway. The student wanted to distribute the literature in hallways during the going between class time. And the district restricted that, claiming that that would cause congestion, likely cause literature being thrown down on the hallway. So it prohibited it. The court decision said that this was unconstitutional. The district had to prove that distributing those leaflets in hallways was going to create a material and substantial disruption to the learning environment. And the district was unable to show that. And because it was unable to show that, it couldn't set those reasonable time, place, and manner restrictions. And when this district decision came out, we were all very concerned about it because this was really setting new law. Fortunately, the Sixth Circuit Court of Appeals overturned that decision, said the district court erred in applying the Tinker standard to the case because the hallways were not a public forum. They were not open for indiscriminate use by the public. They were a non-public forum. And because it was a non-public forum, the district was entitled to put in reasonable time, place, and manners restriction on that hallway speech in order to keep the effectiveness of that forum. In order, the hallways are, meant for students to go to and from their classes, not for distributing literature. So the district was not required to show that a material and substantial disruption. It was able to adopt those reasonable time, place, and manner restrictions that applied to all type of speech, not just political speech. So applying this ruling, you can regulate the distribution of literature by students adopting content neutral time, place, and manner restrictions. You don't have to show they have to show that it's likely to cause material and substantial interference with the operation of the school. Make sure you're not opening your hallways to be common areas open for indiscriminate use. Keep them to be limited, closed forums. And then always remember to be neutral with your regulations. If you're neutral, you're not going to get into that viewpoint discrimination issue. And that's it for me, Pat. I think I'm ready to move into the Q&A.
Thanks, Brad. I think we're going to jump back to Charyn for just a couple of minutes so she can wrap up on her presentation. And
okay, thanks. Can you hear me?
Yeah, Charyn.
yes,
Pat,
but I'm trying to get to,
Pat, I'm going to have you flip then. Is this where we stopped?
yes.
Okay. So the decision maker is going to recommend sanctions, but these sanctions will actually be imposed, but if they find the person responsible. But the Title IX coordinator will send it to the administrator for the appropriate administrator for determination as to whether those sanctions should actually be applied. Now, if they find the person responsible, then the recommendation is to suspend or expel, or if there's special ed implications, you also have to then apply all your other relevant policies. So yes, that might mean a whole nother set of hearings under 5610, 5611 for suspension and expulsion. The other thing I want to say is both sides have the right to appeal. So the complainant could appeal if the decision maker finds the respondent not responsible. The respondent can appeal if he or she doesn't like the outcome. That appeal is simply on a written basis. There's no specification of who handles it, but obviously it can't be anyone who is actively involved in the investigation and shouldn't be the Title IX coordinator. So additional requirements, training, the Title IX coordinator, investigators, decision makers, informal resolution personnel, if you're going to use people to assist in informal resolution, which I didn't even have time to talk about. They need specific detailed training on how to do their jobs in these roles. You also have to provide generalized training for all board employees on their obligations to report, meaning to remind them you are mandatory reporters, and to give them training on how to identify sexual harassment. What is it? And, in my opinion, the default is report it to the Title IX coordinator and let him or her make the final decision. There's also record keeping requirements. This is, by the way, all in your policy, your 2266. You have to keep certain records for 7 years. And if someone says they're being retaliated against for either filing a complaint or participating in the process, that retaliation complaint triggers the Title IX policy, and you have to go through the entire hearing process and investigation process that I just outlined for you. Again, we could spend another 3 hours talking about this. But the policy is very detailed. It's long, but that's because we tried to summarize 2,000 pages and make it meaningful and useful. And if a situation comes up, pull the policy and the answer will be there. Thank you.
Thanks, Charyn. I think now we can switch to questions and answers. And we do have one question that was submitted, and I'll pose that to both Charyn and Brad. And that was a question early on about the, there are several questions here. So let's start with, has anything been resolved with the monthly 30-day issue with regard to approving that plan?
From what I understand, Pat, we are pursuing legislation, MASB, MASA. We're hoping to get that changed, but at this point, it's still in the law. So there is the 30-day requirement of reconfirming your extended learning plan at a public meeting, and until that's changed, that's what boards are required to do. But it possibly may change. We're pursuing that legislation.
Which then answers the second question that was submitted on the same topic, but here's the third. What happens if the board does not approve or reconfirm the plan?
My thought, you're likely risking your state funding under those circumstances. Yeah, because many of those requirements must be followed in order to receive your full foundation money from the state. And if you're not reconfirming that plan, I would say that there is a great risk that you're risking state funding. Would you agree with that, Charyn?
Yeah, that's a little tricky because, yeah, my take on this is, they're asking you to reconfirm the plan because things might change, right? So yeah, in January, maybe there's a vaccine and maybe people who are all online want to go in person. So that's another gray area. I mean, I agree with Brad that you need to look at the plan, assess it, and take input and do something. You couldn't just trash your plan. Let's put it that way. I think it's a little unclear what happens if the board, based on changes in circumstances or even their area being changed to a different phase, wants to go to something different. And that's just something we're going to have to flesh out as it happens. But the key is to make sure that there is a plan that has been submitted in place, and how that's going to work procedurally. To be honest, I'm not 100% sure.
Okay, thank you. There are no other questions that have been submitted. So we're pleased to have had you join us this morning. We'll give you a brief preview of coming attractions. We thought that working on the Title IX regulations, that would keep the U.S. Department of Education pretty busy for months and months, and it did. But that's not the only thing they worked on. You may recall that 5 years ago, they totally revamped all of your uniform grant guidance regulations, resulting in the release of our Edgar policy collection. It's been 5 years, and every 5 years, whether we need it or not, the department reviews those regulations and makes some adjustments to those. They have just released the revisions to uniform grant guidance, and we are working diligently to make required policy revisions and get them to you. They likely will come to you as a special update in the weeks ahead. We also have begun work on Volume 35, Number 2 policy update, and we'll be continuing to solicit some input and get those revisions ready to go. Try to get back to our normal timeline and get that revision out to you late January, early February. If you have questions that we didn't answer this morning, please feel free to submit them either to your Neola associate or to our Neola offices at neolaproduction.com. Thanks for participating. Thanks lots to Brad and to Charyn for their time this morning and their expertise on some pretty tricky topics. Again, we value the work that we do with you and look forward to continuing to serve you as your policy provider in the months and years ahead. We look forward to the September 2021 Fall Conference, where hopefully we will be able to enjoy another policy forum and some informal time at Interlochen on a nice afternoon. Thanks again. Look forward to conversations with you coming up.